Good morning, Your Honors, and may it please the Court. The felony judge's sovereign immunity forbids a federal court to hail these state judges before it solely for the purpose of answering third-party discovery. The key issue in this appeal concerns whether third-party subpoenas constitute suits to which sovereign actors' immunity attaches.
Were they served in their personal or official capacities?
There's no dispute in this case, Your Honor, that they were served in their official capacity.
Okay.
So, and that leads me to the briefing raised three essential issues: that's sovereign immunity, judicial immunity, and then undue burden mental processes. Because there appears to be no dispute that these are official capacity subpoenas, the court doesn't need to reach the judicial immunity defense, since that would apply in a personal capacity suit. So this morning I'd like to focus my argument on the two remaining issues: sovereign immunity and undue burden. Turning first...
Is it really true that judicial immunity, that the personal capacity in that is not the same thing that we mean in your personal life? Your personal, it means as a judge. So why isn't judicial immunity really the better, easier route, since sovereign immunity's not, there's not a lot of law to help?
So I think these subpoenas were served on the judges' offices, and I think we can tell that from the fact that when several of the judges lost elections, their successors had subpoenas served on them. I agree we could prevail on a judicial immunity defense, but I do think in this official capacity scenario, the sovereign immunity defense is the most appropriate, and I think we can see that from several circuit cases, including one from this court, Sparks and Bonnet from the 10th, DeJordy from the 8th, Downey from the 4th, and General Electric from the 2nd, all of which hold that sovereign actors have immunity from third-party subpoenas.
But no one's ever held that with regard to judges, right?
So I agree that those cases were federal sovereign immunity and tribal immunity cases. But there really is no distinction. In our view, that's a distinction without a difference, because there's no reason to define the same term suit to mean two different things depending on who the subpoenas are being served on. So we haven't seen any argument, I think, why that would matter. And indeed, the question here, I think, again, is whether third-party subpoenas constitute suits in really the sovereign immunity sense. These circuit decisions do hold that, I'll quote Sparks, "A court, state, or federal lacks jurisdiction to enforce a subpoena against an unwilling sovereign." That's at page 235, and that's from this court in Sparks. I think the court can resolve this appeal in a straightforward application of that precedent and the others I mentioned in the sovereign immunity context from other circuits. Again, Bonnet, DeJordy, Downey, and General Electric. And I'll say those cases are grounded and draw from several Supreme Court precedents. That's Dugan, Larson, and Cohen's, all of which help to define what a suit against the sovereign might be. And Cohen says that a suit is the prosecution, pursuit, or pursuit of some claim, demand, or request. And Dugan and Larson really put some flesh on that and sort of outline what I'd say are three hallmarks of a suit. You have an effect against the public treasury, you have an interference with the public administration, and the final one is if the effect of the judgment would, in some sense, compel government officials to act or restrain them from doing so. I think...
Is any of the discovery related to personal actions of the judges, or is all the discovery related to what the judges did in administering the bail schedules, or what?
My understanding of the record is that it's the latter. It's all of what the judges...
There's nothing that they're personally involved or something about them in their personal life.
No, of course not. It wouldn't be, for example, that they were outside in the street and saw a car wreck, where, of course, we wouldn't dispute
right.
that they could...
So, okay. Again, I don't, to the extent that they're being sued because they're county officials, which you can talk about whether felony judges are county officials really or state officials, and we could have a big discussion about that for 2 hours. Why isn't judicial immunity the right answer.
So-
If they're county officials and they're sued about what they did in administering a county policy, why isn't that a bright line thing that it's an existing immunity? It doesn't have to be an extension of the law to a different context.
A couple of responses, Judge Elrod. The first is that I would push back a little that these state judges are county actors, I think, and I don't want to bog us down too much in that because that's not really a dispute here, but I would point to the court's recent en banc decision in Days.
I understand the issue
That-
my past life, you know.
Sure. So if the court does think that personal capacity, that these were served in the felony judge's personal capacity, I do agree with you that judicial immunity would.
But even if they're so served as officials, you can still get judicial immunity, can't you?
I think in Lewis versus Clark, the Supreme Court said in a personal capacity suit, that is a judicial immunity defense, and in an official capacity suit, it's sovereign immunity is the appropriate defense. So we're looking to that case for that. But Judge Elrod, I agree if we're looking at this through a judicial immunity lens that we still would prevail. I do think this court en banc in Daves did say that these are judicial acts.
Can the plaintiffs go to state court to get these subpoenas?
Could they get so if the question would be if there was a separate action in state court, could
Why
they?
can't they say we need discovery in this federal lawsuit and we need to get it and we can't get it through the federal lawsuit?
Well, I think that.
Can they go to state court? Is there a mechanism for them to get this discovery?
So, two responses. There's of course the Public Records Act type request that you could go through. There's one specifically under Texas law for judges. Now, if the question is whether they could go and
Would it bar administrative decisions? Would the Public Records Act still protect or exclude the disclosure of things related to your job that are part of the administrative hat that many judges wear?
So I'll turn to it right here. There are several categories of documents that are excluded. One includes judicial work product. I guess it would turn on the exact nature of what you're referring to with respect to administrative.
Right, you have to make decisions in your job at the court about all kinds of policies and how we're going to handle these kind of things, these kind of cases. It's not a ruling in a particular case, but it is how to administer the court's work.
So to the extent that it is a sort of a judicial capacity action, it might well, under Texas law, bar that. Again, under state law, under the Texas Rules of Judicial Administration, it's Rule 12. There are certain categories of documents that are excluded, and there's an administrative sort of remedy under there for appeal of a decision. So there is that mechanism they could go through, as we point out in our brief. To turn back to your question, in state court, though, if I understood you to be asking about state court, that would entail separate questions of governmental immunity under state law. So I don't know that they could go to a state court and get this, but certainly in federal court, we do think sovereign and judicial immunity would protect them.
It seems that the district courts seem to say, well, as long as we follow the federal rules and we're very careful and we balance, that's enough protection. It seems like you can get that the federal rules themselves are enough. Do you have any comment on that?
Yes, I don't think the federal rules abrogate state sovereign immunity in any sense. Certainly, I have not seen any argument about that. Certainly, Congress can't abrogate state sovereign immunity under its Article I powers. So it's hard for me to see how there would be how the federal rules could overcome a sovereign immunity defense. Indeed, I don't think it could, and that's precisely why we have several cases applying sovereign immunity. Again, tribal context, federal sovereign immunity, but we think that's a distinction without a difference. Moving very briefly to the undue burden issue, the court doesn't need to reach that one if it reaches it either through sovereign immunity or judicial immunity, but that is a method of constitutional avoidance. You were mentioning, Judge Elrod, a lot of cases flying around in the sovereign immunity context. The court could, if it wishes, follow the path that the panel took in Whole Woman's Health versus Smith, and under principles of constitutional avoidance could rule under Rule 45. And we'd point specifically to the relevance and need factors. The claims here, I think it's important to note, are against the hearing officers and what happens in their courtrooms, not against the felony judges. Indeed, they're no longer parties to this case. And there were a couple rationales offered by the district court on this score. One was that, well, we want to know what the felony judges do in their own courtrooms if they're following the Constitution there. Again, that's outside the scope of this case. The felony judge's conduct is not relevant. And another rationale was that, well, maybe the felony judges could issue rules to govern the conduct of the hearing officers. 2 points on that one. First is that the plaintiffs themselves admit that in 2017, the felony judges gave the hearing officers greater discretion over individual bail setting. That's in the complaint. And, of course, the failure to exercise rulemaking authority is not relief that could be had against the state actors under Ex parte Young.
Were objections filed to each and every one of these requests? So such that if we're going to do that kind of analysis, you would need normal kind of discovery objections, and that it's not a big it's not an immunity that just jumps in. You need to have particularized objections, don't you?
I would agree with you that it's not an immunity. It's not as broad sweeping as the
Are
other
there
side.
Particularized objections in this case that were filed timely?
I believe there were some. I'll have to go back and look.
Nobody really talks about that. But then we get to this whether it's an undue burden, we would look at those particularized objections and construing that.
So the court in Whole Woman's Health versus Smith didn't take that approach, and it looked at just need and relevance, and I think the court could follow that approach there. If there are no further questions, I'll reserve my time for rebuttal.
Okay. All right. Ms. Datla.
Good morning, Your Honors, and may it please the Court. My name is Kirti Datla, and I represent Mr. Russell and the other plaintiff appellees. I want to start with just a brief thematic statement and then jump right into some of the questions. In our view, for a trial to be a fair contest, cases have to be tried on a full record with the facts aired to the greatest extent possible, and third-party subpoenas allow courts to do that. For centuries, these subpoenas have issued to public officials, and for nearly 2 centuries in this country, there has been not a peep about sovereign immunity. Officials did resist subpoenas, but they did so on the grounds of privilege or burden, not sovereign immunity. The felony judges asked this court to import sovereign immunity into discovery and to undermine the public's right to every man's evidence. Before doing so, this court should require some hint that anybody thought these subpoenas were incompatible with sovereignty, or at the very least, some evidence that the status quo isn't working, given that every court, nearly every court, to consider this issue allows these kinds of subpoenas to issue to state officials, and they haven't done that.
Counsel, why would we, if we were to look at the relevance and the burden, why wouldn't that alone be enough in this case if they're not the decision makers, and whether or not they could have done a policy is not pertinent to someone else's liability?
So I think my friend on the other side's description of the claims in this case is not accurate. We sued Harris County and its sheriff, and the allegations are that the bail orders that the sheriff enforces are unconstitutional because they issue without the required process and findings that are necessary to support these bail orders. Both the hearing officers and the felony judges issue bail orders, and they have concurrent jurisdiction in Harris County, and the felony judges also frequently revoke bail orders that are issued or revise bail orders that are issued by the hearing officers. So they're players.
Wrong, though, are you?
I'm sorry, Your Honor, I can't hear you.
You're not saying the felony judges did anything wrong, though, because they're not parties.
The hearing officers are also not parties, Your Honor. We're saying that the bail orders that are being enforced are not constitutional, and multiple people are involved in the issuance of those bail orders. So what the felony judges do is relevant because they issue some of the bail orders that are issued in this case.
Okay, so you want to look to see if a judge's work product to determine if their judicial decisions were constitutional. Why would that not be judicially immune, regardless of whether it's sovereign immune? Or why wouldn't the mental process exception govern it?
So I want to give a formal answer to the question, and then I want to address what I think is the concern underlying Your Honor's question. So the formal answer is that both the sovereign immunity question and the judicial immunity question have the same threshold question in common, which is a third-party subpoena a suit? And in our view, it just isn't, because all it does is say, please give us this information subject to any and all existing privileges. It doesn't adjudicate any claim of liability against the recipient of the subpoenas. And that's important because in both contexts, that's relevant to why we have these immunities. In the judicial immunity context, it's relevant because the idea of a damages suit might influence how judges do or don't issue their decisions. Courts in other contexts have said the idea that, in the Mohawk case, for example, which deals with attorney-client privilege, the idea that something might be disclosed down the line doesn't have that same kind of influential or interorum effect over decisions. So in our view, judicial immunity is about liability. It's mostly about liability for damages, and it just doesn't apply here. But we certainly agree with Your Honor that anytime there's a third-party subpoena, the recipient is going to be concerned about what kind of information is divulged. And our view is just that the law has a way to deal with that. There are all sorts of privileges that apply here. For example, the deliberative product privilege would probably address most of Your Honor's concerns, and we haven't heard any argument from my friend on the other side about why that wouldn't be, exactly what you would need to avoid the kinds of concerns that you have.
What can you get from them? Because everything has to do with their mental processes in their judging life. If that's what you're trying to find out is their decisions in bail, what can you legitimately get from them in this subpoena? What would not be privileged?
Certainly. So I'll give you a couple of examples of the kinds of things we're looking for, but I would also just point you to the requests themselves, which ask for things like, is there any data about how many on-the-record hearings there are? Are there any training manuals that say, that would give us some idea of how these proceedings go? Do you have any kind of standing procedures that govern these procedures so we can know whether all the requisite procedures happen? So, just on their face, they're not asking the kinds of questions that I think Your Honor is concerned about, which is, tell me why you did what you did, or tell me what you were thinking when you issued those decisions. That's not what we're looking for. But let me just give you an example of what we do need information about. So we have basic questions about what's going on in these hearings before the felony judges, and we don't have a complete window into that information because, for example, sometimes bail is revoked without defense counsel present, so we can't ask them. And the docket sheets that issue out of these cases are often incomplete, so there won't be information about whether the defendant was there, or they have inconsistent information, so that's not that helpful. And then the bail orders that actually issue out of this system, they don't have findings on them. They don't indicate whether any evidence was taken. And those are the key questions in this case. Did the judge make findings? Did they allow the taking of evidence? That's the kind of thing we're looking for. And we did try to ask Judge Warren, you've told us what your procedures are, but can you tell us what the other judges' procedures are? And he said no, for the kind of obvious reason that he's not in their courtrooms, and so he doesn't know. So that's just an example of the kind of...
Excuse me.
I'm sorry.
Aren't the bail hearings open to the public?
Sorry, Your Honor.
Aren't the bail hearings open to the public?
So my understanding is that because of the pandemic, some of the bail hearings might have been streamed, but there are no transcripts, and I think that we aren't allowed to capture those recordings. But I think if Your Honor's point is, could somebody sit in every single courtroom of these hearing officers and every single courtroom of these felony judges every day and try and capture that data, that might be a theoretical possibility, but that's not what Rule 45 requires. That would be an immense effort versus all that we're asking for from the judges is there information that you can give us that will give us a general sense of your procedures so that when we go to court and try and establish whether, as a general matter, are the required process or the processes that we think are required under the Constitution happening in these proceedings, we can know whether the answer is yes or no.
When you say they're procedures, do you mean whether you have a hearing or not, or whether there's counsel present or not? Those would be the local rules or things. Those would be public already.
The claim in this case, Your Honor, is that procedures that we think are constitutionally required and procedures that might be required by rules or statutes aren't happening. That's the same claim that was in O'Donnell, where the findings were made that, yes, these procedures are not happening. That's the whole claim in the case, and that's what we're trying to find information about.
But then that means you want to ask judges, did you make sure in this case that the lawyer was present? And did you open it to the public? And did you do an individualized assessment of the defendant? Those are decision-making. That is the core to the judicial process, all of that, to talk about particular cases under subpoena.
So again, I don't think, and this I think goes to the mental process rule, which is, we will say two things about it. One, it's a testimonial privilege, and two, it's a privilege that can be overcome based on the needs of the case. And I don't, we can get into whether this situation is quite different than all of the cases that they've cited. But as Judge Rosenthal found, we don't plan to ask any judge, tell me why you issued this decision. All we want to know is, tell us whether when you hold a bail hearing, is it on the record? Do you allow defense counsel to make arguments? Do you allow the defendant to present evidence? Do you make findings on the record? Is there a transcript? Those are the kinds of things we want to know. And I take Your Honor's point that those, occur in a courtroom. And so in some sense you can, they're obviously judicial in some sense, but they're not the kinds of things that implicate the mental process rule, which is a specific privilege that says you can't, as a general matter, ask the judge the why, because usually there's a record and an opinion that you can rely on and get those questions from.
Are you saying, and I'm not really that familiar with the way it's done in Texas, but are you saying there's no record, no administrative data or whatever that's not retrievable, that maybe doesn't give the full of what you asked, but the contours of what occurs in the bond setting aren't, set out in such a way? I'm asking it there because I'm just trying to figure with all these people, people setting bonds and depending on the numbers, how, pray tell, one remembers, when Joe Dokes came through, da-da-da-da. You know what I'm saying? I'm just saying you're subpoenaing people.
I'm sorry, Your Honor.
You're subpoenaing to get information, not the mental processes, but about what took place, right? So if you're not trying to get the mental impressions and you say you're just trying to find out what's, for example, my methodology, is that what you're seeking? In other words, what's the methodology, if I were that judge, used in that court, right?
That's right. Yeah, it's maybe an analogy is as Judge Elrod said, we're trying to figure out what the equivalent of the rules of procedure are in these judges' courtrooms, and that is something that is, looks much more like the kind of administrative or, regulatory decision that you
Well, let me ask it this way. If there were, I don't know how theirs works or how many people there are, but let's just say there are 10 sections of court that do this, right? Whatever the number. So you're trying to ascertain if in all 10 sections, each of the felony judges does the same thing or comports with the constitutional standard, right? Is
Yes,
that what you're after? So wouldn't there be base parameters in the court's rules or policies or something that, one judge might personalize to an individual, somebody else it's very short, so it's gonna, by definition, differ with each judge, but isn't there a baseline that's retrievable of what each, person is supposed to? Sometimes there are checklists and so forth that people use, so there's no data. What I'm really trying to get is from the court administrator, from the court, from the transcript, there's no data that supports the request. It has to be to get the information from the judge, him or herself. Is that the bottom line?
Thank you, Your Honor. That's our basic point, which is this is a situation, especially because these hearings are so informal and there are so many of them. It's just, and the data, as I mentioned, the data that we do have access to is often inconsistent. It's just not possible for us to figure out these kind of basic questions without asking the judges for documents and asking just a couple of the judges, carefully selected, questions along the nature of what I've been discussing.
Well, let me ask you one more question, and I have it right. Did I understand, and I don't purport to understand all, that there were some felony judges who received the subpoenas but who complied?
Yeah, so there are some judges who are not represented by the state of Texas. All of those judges took the bench in 2019, and all of those judges basically are in the same position as Judge Warren. And when we took Judge Warren's deposition, he answered questions along the lines of, I don't know anything that happened before 2019. You have to ask the judges that were here then. I don't know why this document was put in place. I don't know what this order refers to. And so that's why we need to ask, just a couple more judges questions, because they have experience that he doesn't.
Right, but those judges are not here anymore, some of them. So the records are no longer in their custody if they are not the judge of the court. So they can't produce those documents anyway if they're former.
The document requests were, I agree with Your Honor that this official capacity, personal capacity distinction is odd in the context of a subpoena, but I think the reason it's odd is because a subpoena isn't a suit and it's not seeking any relief against the judge. But we do agree that all we were seeking is documents they would have because they were judges.
But they're not, at least one of them for sure is not a judge anymore.
Sure.
They don't have you don't take the documents home with you.
And I think that's what my friend on the other side was referring to when he referred to people being substituted in, which is that we've asked for these documents that cover certain data periods. It frankly doesn't matter which judge has them in their custody, as long as they're still in the custody of, the records custodian for these documents.
Couldn't you get this information about procedure from your 5 clients?
Well, again, this is a putative class action, so we have asked our clients for some information. We also allege in the complaint that some of our clients were not present for their hearings, even though the docket sheet says, that they were there. So we know what happened to our clients, but this is a putative class action, and we're making claims about the felony bail system in Harris County more generally.
Has the class been certified?
There's a pending motion for class certification. The class has not been certified in part because there's lots that's missing from the record. I do want to just quickly address the sovereign immunity point. And I want to make, I think in reading the reply brief, the heart of the argument from the felony judges relies on Dugan. And I want to make one point about why Dugan isn't on point here, and another point about why, even if it is, the subpoena is still not barred by sovereign immunity. So as I think my friend on the other side started out, with respect to sovereign immunity, the question here is this a suit? And we've given you all sorts of reasons why it's not, as a matter of the way that word was used, both colloquially, as anyone would on the street today, and at the time of the founding. A suit is when you sue somebody as a defendant, saying they violated your rights, and you ask the court to grant you a remedy. All a subpoena does is ask for information subject to existing privileges. And I don't think that Dugan says anything about whether something is a suit. And that's because in Dugan, everyone agreed there was a suit. The first 3 words of that decision are, this injunction suit, because the plaintiff sued federal officials, and he said, you violated my takings rights, and I'm asking for a remedy And the remedy in that case was basically to either dismantle a dam or build a new one. Of course, that's a suit. Of course, it would have been barred by sovereign immunity if it was against the government. And that was the question in the case. Does it matter that they sued officials instead of the government? And that's what that language in Dugan that my friend on the other side and the cases he rely on. And this just doesn't look like any of the cases where Dugan has been applied to say that a suit against an official is actually a suit against the state.
Why shouldn't all of this be pre-termitted until such time as the court determines if there is a class action? Because if there is not a class action, then there wouldn't be allowed to get all the information from all the different judges, even if you would be allowed to know the ones that were allegedly had been involved in these cases.
So I'll say two things. One, that's not an argument that my friend on the other side has raised, so it's forfeited. But the second thing is that all of this is relevant to the issue of class certification as well, and that's something that Judge Rosenthal found in her opinion, because it speaks to things like typicality and whether there are common issues of fact and all of that. But I just want to finish up that thought about Dugan. The cases that find that suits against officials are actually suits against the government relying on Dugan involve things like requiring the government to perform on a contract, or the cases from this circuit involve cases where the claim would have resolved title against the government. And this just doesn't look anything like those cases. It doesn't interfere with the state's treasury or its property or its policy-making authority in any way like that. It looks much more like the other categories of suits that have been found not to resemble suits against the state, and those are things like ex parte Young suits, where any burden is minimal, and also the habeas writ, which that would obviously be a suit under Dugan, but everyone knows that doesn't implicate state sovereign immunity. And one of the reasons it doesn't is because there's an extraordinary history of habeas writs at the time of the founding and no state objecting. And that's what we have here, just to go back to what I said at the beginning. We don't have any evidence that any case has found a proceeding like this, which doesn't adjudicate any liability, implicates sovereign immunity, and we don't have any evidence that anyone objected at the time of the founding or afterwards to this on sovereign immunity grounds. And this is an area where states guard their sovereignty closely. They object when other states waive their sovereign immunity, and we don't have a peep in any of the cases, in any of the treatises cited, or anything like that. So we'd urge this court to affirm.
All right, thank you. Back to you, Mr. Cole, for rebuttal.
Thank you, Your Honors. I want to make 2 points in rebuttal. The first has to do with sovereign immunity, and the second is I'll return to the undue burdens analysis Your Honors were discussing earlier. On sovereign immunity, taking the habeas point first, a habeas writ is not against the state because, at least since the time of Blackstone, it's against the jailer and not thought to be against the state. So habeas doesn't provide any helpful analogy here. It was the king's prerogative to inquire as to the jailer why one of his subjects was in custody. More broadly on sovereign immunity, we're relying principally on several circuit cases that do in fact hold that third-party subpoenas are against the state and they are suits with respect to sovereign immunity. So they rely on Dugan, and I certainly wouldn't quibble with my friend on the other side that Dugan didn't involve third-party subpoenas, but nonetheless the principles it announced were drawn upon by this court in Sparks and DeJordy, Downey, Bonnet versus Harvest, and U.S. EPA versus General Electric, all the cases we cite in our reply brief. So that's why Dugan's relevant. It's drawn upon by the many circuit cases that hold that third-party subpoenas are suits.
Counsel, the felony judges acted in their judicial capacities in creating guidance for setting bail, correct?
Undoubtedly so. The court held as much in Davis.
Yes. And they would be acting in their judicial capacity in these answer to these questions, because none of this is about their personal behavior or watching a car wreck or whatever, right?
Absolutely, Judge Elrod.
But the district court held that judicial immunity did not apply at all and did not address to what extent judicial immunity would protect against each of the requests. Is that correct?
The court, I believe, just said that the judges were acting in their administrative capacity and not a judicial capacity. That was the principal
But it was
ground.
judicial capacity, wasn't it?
It was. I agree with you.
So shouldn't we remand for the district court to analyze if they are acting in their judicial capacity, whether judicial immunity would apply, because the district court did not actually grapple with that because it just kind of passed it off?
I don't think
a very learned district court who was centered on a bunch of other things in the case. So that's not a criticism of the district court.
No doubt, Your Honor. I don't think remand is necessary. I think the judicial capacity question flows very naturally from what the court...
But couldn't we do a limited remand for the district court to analyze judicial capacity as to each of these discovery issues, line by line? If it requires a line by line, we shouldn't do that ourselves.
I'm not sure it does require a line-by-line analysis. I think the court could just apply what it said in Dave's a few months ago.
But we did that in the June medical. We sent that line-by-line analysis request about the privilege back to the district court on a limited remand for the district court to do that, because we don't generally grapple with discovery requests and line-by-line analysis in the first instance.
Nor would I ask this court to go line-by-line to the discovery. I confess I'm not up to speed on June medical and what the court did there, but I think the court could really just apply Dave's and what it said there, and if the court disagrees with me on that, that might be a reason to decide this on sovereign immunity grounds.
Well, yes, if sovereign immunity applies, there's no need to look at the judicial immunity. Is that correct?
Absolutely, absolutely. Turning finally to the last part about the beginning, the discussion you had with my friend on the other side, I think I want to be clear that I don't understand the record to reveal that any of the claims are against the felony judges as such. There was a lot of questions about, well, we need to learn about the procedures in courtrooms, but the relevant courtrooms are the hearing officers' courtrooms, and they can certainly get information from the hearing officers. Indeed, they've done so. So the action is not against the felony judges. There's no relief being sought against the felony judges. Bail in this case in Harris County is typically set in the hearing officers' courtrooms. So what happens in the felony judges' courtrooms is simply irrelevant.
So does the felony judge just sort of endorse what the hearing officer found? I'm just not, in time doesn't permit me to know every place does it differently. So does the felony judge essentially adopt what the hearing officer determines?
Well, I think
Yeah.
I think what happens generally is after indictment, the case goes up to the felony judges, and then there can be a bail review hearing if it's requested. I couldn't speak to the resolution of those cases.
Well, I was just trying to get to understanding your point there was whether or not the base of information lay in the hearing officers as opposed to the felony judges, or whatever data or records there are might be there in whatever this sort of tiered system is, and that's just kind of fuzzy to me. Well, let me just ask a question rather than making a statement. Is it your view, or do you agree that there really is not a data pool, so to speak, for want of a better way to put it, of information that's in the system, quote unquote, that's not the purity of what, if the plaintiffs say they don't want to know what's in the judge's head, but process. So do you agree that there's not sort of a data pool somewhere in there that contains, what happens within the system? I mean, it's an all or nothing proposition.
So I'm not aware of any data pool, and I'd be surprised if it was in the...
That's probably not a good term, and I don't...
Fair enough. I'm not aware of any sort of thing approaching a data pool that would be housed within individual judges' chambers. I imagine it would be in the court administration system, and they can subpoena those people perfectly fine. And indeed, they have. They've taken depositions of pretrial services, the district attorney's office, the public defender's office, with no problem. So,
one last question, just so I clarify.
Absolutely.
And that was, if I understood it, there are some of the felony judges who were subpoenaed who either complied, I guess. Is that right?
That's correct. I know they've taken at least one deposition of a felony judge, and I believe there are at least 5 others who did not move to quash the subpoena, and so presumably they could take those depositions and needn't try to take the depositions of these 17 remaining.
Okay. All right. Well,
Thank you.
So 17 remaining, and there are at least 5 or so that either have complied or not. Is that right? Give or take.
Yeah, I think that was right. There was about 23, and then 6 of them didn't join in, and so 17 remain in this case.
All right. Okay. Thank you both for your
Thank you.
briefing and the oral argument provided in the case. We'll take the case under submission, and we will get it decided. Before we call up the 4th case for the morning, 21-30534, the panel will stand in just a real brief recess, but counsel in there, you're welcome to come on forward and be at the table, and when we come back, we'll be ready to roll. Court will stand in a brief recess.